Reconvene the Lane County Board of Commissioners for this Tuesday afternoon, December 6th session. We have several public works items to work through, and then an executive session, and then also a sheriff's office item. So with that, I'd like to start with 13A. It's order 16-12-06-07 in the matter of electing whether or not to hear an appeal of the hearings official's decision approving a legal lot verification and notice for 4 parcels within properties identified as assessor's map and tax lot 16-04-10-00-00800 and 02201. It's file number 509 PA 16-05590 Farver, and we have with us Rafael Saba, our senior planner. Good morning, or good afternoon.
Good afternoon, Chair and Commissioners. This item is an appeal to the Board of County Commissioners contesting hearings official decision affirming a planning director approval of the legal lot verification for 4 parcels within the 2 tax lots that you mentioned, 800 and 2201. Sean Malone, representing the appellant, Landwatch Lane County, filed the appeal pursuant to Lane Code 14.515 and requested that the board not conduct a hearing on the appeal and deem the hearings official decision the final decision of the county. The hearings official has reviewed the appeal and found that the allegations of error have been adequately addressed in his decision and do not warrant further consideration. The appellant has also, as I stated, requested the board not conduct the hearing. Lane Code Chapter 14.600 Sub 3 establishes the approval criteria for this elect to hear meeting. As explained in the agenda cover memo, the director does not believe these criteria are met and recommends the board adopt and expressly agree with the hearings official decision as outlined in option 1 of the agenda cover memo. I'm happy to answer any questions you have.
Questions for staff? Comments? Entertain a motion if there's no questions. Commissioner Bozovich?
So I move approval of Order 16-12-06-07 in the matter of electing not to hear an appeal of the hearings official decision and affirming the hearings official's decision as final decision for the county on a legal lot verification and notice for 4 parcels within properties identified as assessor's map and tax lots 1604-10-00-0800 and 02201, file number PA 509 PA 16-05590.
Second.
To be clear, whether or not you expressly agree with the interpretation.
Sorry, I didn't use those exact words. Affirm, I said affirm, expressly agree. Yes.
Okay. So we have a second? Second. Okay. Any further discussion? All in favor of the motion?
Aye.
Aye.
Any opposed? Passed unanimous. Our next item B is a similar. It's order 16-12-06-08 in the matter of electing whether or not to hear an appeal of a hearings official's decision approving a legal lot verification and notice for 2 parcels identified as assessor's map and tax lots 17-06-10-00-02402 and 02403. File number 509 PA 16-05596, and this is Swanson. Mr. Saba.
Thank you. This is a very similar appeal of hearings official decision affirming a planning director approval of a legal lot verification for 2 parcels identified as tax lots 2402 and 2403 of map 170610. Lori Siegel is representing the appellants Landwatch Lane County, Robert Emmons, and William Dunham. And again, with this, as with the previous appeal, they have requested that the board not conduct a hearing and deem the hearings official's decision the final decision for the county. The hearings official has also reviewed this decision and has similarly found that the issues have been adequately addressed. In addition to the appellant requesting that the board not conduct a hearing, the applicant wrote a letter and also requested that the board affirm, adopt, and expressly agree with the hearings official's decision. Similar to the last item, the director doesn't believe that the approval criteria or that the decision criteria in 14603 are met and recommends the board adopt and expressly agree with the hearings official's decision as outlined in option 1.
Okay. Questions for staff? Seeing none, I'd entertain a motion. Commissioner Bozievich.
So this time we'll see if I can do it correctly. I move to adopt Board Order 1612-0608, electing not to conduct an on-the-record hearing for the appeal, affirm and adopt the Lane County hearings official's decision as the county's final decision, and expressly agree with and adopt the interpretations of Lane Code 13450, 13010, and 13020 made by the hearings official in the decision.
Second.
We have a second. Comments? Discussion? Seeing none, all in favor of the motion?
Aye.
Any opposed? Pass unanimous. Thank you.
Thank you.
Okay. We have 3 items here that are fourth readings and deliberations. I'll look to staff. Would you like me to read all 3 items into the record and then we discuss them
Please do, yes.
together? Okay. So with that, item C is a fourth reading and deliberation ordinance number PA 1304 in the matter of amending the Springfield urban growth boundary, the Eugene Springfield Metropolitan Area General Plan, commonly known as Metro Plan, text and diagram, to amend the Metro Plan boundary, adopt the Springfield 2030 Comprehensive Plan, economic and urbanization policy elements, and assign plan designations to newly urbanized lands, the Springfield zoning map to assign new zoning, the Springfield Development Code to add sections 3.2 through 915 through 3.2-930, establishing the agricultural urban holding area land use zoning district, adopting a severability clause, and providing an effective date. Item number D is a fourth reading and deliberations for ordinance number PA 1341 in the matter of amending the Lane Code Rural Comprehensive Plan to modify official county plan and zone maps to reflect the expansion of the Springfield urban growth boundary as amended by the county ordinance number PA 1304 and adopting savings and severability clauses. And finally, item E is the fourth reading and deliberations for ordinance number 16-05 in the matter of amending Lane Code Chapter 10 to reflect adopted amendments to the Springfield Development Code to add sections 3.2-915 through 3.2-930, establishing the agricultural urban holding area zoning district, AGLC 10.600-15, and adopting a savings or a severability clause. Then we have Keir Miller.
Thank you, Chair Stewart, and good afternoon, Commissioners. This is the board's fourth reading on the 3 ordinances before you. The board held a third reading on these items back on November 7th. That was a joint deliberations with the Springfield City Council and the Lane County Planning Commission. Just to refresh your memories on that, at that time, the Springfield City Council made a motion to tentatively approve the ordinance enacting the Springfield 2030 and urban growth boundary expansion items. The Lane County Planning Commission recommended the board approve ordinance number 1304 and 1341 at that time. Last night, I can report that the Springfield City Council unanimously approved their ordinance number 6361, which is substantially identical to the county's ordinance number 1304, which sets the stage for the board's deliberations today on these ordinances. There was a lengthy staff report and findings presented during the last hearings, and at this time, this meeting is for the board. You did perform some deliberations back on the 7th, but at this time, staff is recommending approval of the 3 ordinances, and I'll just say that Springfield staff, the Public Works Director, Annette Spickard, as well as County Counsel and Linda Pauley, the project manager, and Tom Boyette are all here in the audience if there's additional questions on this item. But with that, I'll leave it open for questions.
Great. I guess I'd just start off with one. If I remember correctly, we reopened the record and closed it with, that was really just to verify, I think, the record. Was there any changes, or was it?
I don't believe so.
Commissioner Stewart, I can report.
Please come forward.
Chair Stewart, I can report there were no changes to the record. We left it open, posted on the website, and didn't hear from anyone.
Great, perfect, thank you. Other questions from commissioners, comments? We're a quiet bunch this afternoon. Commissioner Bozovich?
So I first have to apologize for having missed the 3rd reading, or I probably would have asked this question sooner. I still am dealing with a lot of questions around the urban growth boundary alternative analysis that was done and the findings around that. As you're looking at the different priority lands, and there's statutory reasons why you can determine they're not buildable. My understanding is we can, in that process, or at least what I see statutorily, and it talks about inventoried wetlands, and there was use in this, or at least some reference to, in some sections, hydric soils and possible unmapped wetlands being on parcels as part of the elimination process. Legally, are you allowed to look at because the only inventory we've adopted in Lane County is the National Wetlands Inventory maps for rural, at least rural, and I don't think the city's gone beyond that inventory these areas. You know, I'm thinking that, the fish hatchery property. One of the reasons it was looked at and kind of tossed aside, 50 acres of rural industrial, was the possibility of wetlands on it. But it's not inventoried wetlands. Will that stand up as a finding without an inventory? I mean, I'm looking for the kind of statutorily. I see the word inventory wetlands in the statute, but I'm not seeing possible wetlands in the statute.
The city did not rule out any properties in the Goal 14 analysis based on wetlands or hydric soils. So there may have been mention of that in the findings as part of a description of a property, for example. I'm not certain about the parcel you're talking about.
I'm trying to get back to the right page number. Unfortunately, when you open and close these things, it comes back to a different page number. So I'm not getting to the page number, but specifically, I think it's the Mohawk A area that I'm talking about, that I can't remember, in that portion of the findings, it kind of determines that it's unsuitable, mostly because of potential wetland impact on the site. It sounded like, and I don't have that in front of me right now. Unfortunately, I can't look to see if that was just a description or if that was the actual finding of why.
That was just a description. So we used the inventoried wetlands that are from Lane County's inventory, which in lands outside the urban growth boundary was the National Wetland Inventory. That's the GIS layer that we use to screen those lands, all the study areas outside the UGB.
Okay, yeah. And I still question, some of the elimination of the, I hate calling them CV Loop, I like to call them College View, but some of those areas also that were exception, second priority lands I guess the parcelization is probably the main reason for it, but, I'm still struggling with my comfort level of getting to resource land in the North Gateway area versus some of the exception lands that would be higher priorities. And I just wanted to try and get in my mind that we weren't eliminating areas for non-inventoried resources versus inventoried resources. So if you're, I'll trust the statement without having to be able to go back and find the page again, unfortunately, of the 500 and some that's in that attachment, that at least Mohawk was not eliminated for non-inventoried resources.
That's correct.
Okay. Other questions for staff? Commissioner Lycan?
Thank you, Mr. Chair. So Linda, I may need you here again, so I apologize. If you could refresh my memory, I used to know this, but now I don't remember. So question I have, so House Bill 3337 passed in 2007, which of course separated the urban growth boundaries. The Springfield began this process, was it in 2008 or 2009?
It was initiated in 2007, both the residential land study and the commercial and
That's right,
industrial land.
residential and then the.
And we did them simultaneously.
Yeah.
And both studies were for the planning period 2010, 2030, so they're coordinated. And that's why some people ask, why is it taking so long?
Yeah. So this is the 2030 plan. We're in 2016, almost 17. So is this something that you literally could take up again in 2030? So this began in 2010 for the 20 years, and then after 2030, is this something that can be initiated again to look at available lands, or how does this work?
The cities are required to have a 20-year supply of land. So I guess if there's evidence that comes forward that shows that the city has used up all of those lands
Right.
prior to the planning period ending, then the elected officials, I believe, could initiate another study, another look at it.
And I'm hoping that after the work that the city did on College View, that will remain part of this, because I still believe that I believe College View gives you much more future growth, where going north, you're obviously going to be stopped eventually here, and I don't even think you can go all the way to the river anyway, so you're going to eventually be stopped. And so that's where I'm hoping that the College View, because you did a lot of work on that, and hopefully that's going to be something that just won't collect dust, but that's going to be something that would be available for, again, growth out in the future when other elected officials are in play. You may not even be there then, so who knows? But anyway, so I'm hoping that's going to be the case.
Yes, and we have an extensive public record of all the public input that went into that process, because we did a lot of study of that area.
Yes, you did. So, okay, that's really all the questions I had, and I appreciate it. Thank you.
Any others? Seeing no further questions, I'll look to Mr. Miller. Do you want just a motion on each one separately for approval?
That'd be great. Yes, please.
I'll look to my colleagues for direction. Commissioner Lycan.
Mr. Chair, I move approval of ordinance number PA 1304, the matter of amending the Springfield urban growth boundary, Eugene Springfield Metropolitan Area General Plan, also known as the Metro Plan, text and diagram to amend the Metro Plan boundary, adopt the Springfield 2030 Comprehensive Plan, 2030 Plan, economic and urbanization policy elements, and assign plan designations to newly urbanizable lands, the Springfield zoning map to assign new zoning, and the Springfield Development Code to add sections 3.2 -915 -3.2 or excuse me, 2 through 3.2 -930, and establishing the agricultural urban holding area land use zoning district, and adopting a severability clause and providing an effective date.
Do we have a second?
Second.
Any further discussion on the motion? Seeing none. Commissioner Bozovich.
So I'll probably be the lone dissent on this, but I'm not going to vote to support this motion. I still am not comfortable with the exceptions land studies in this, that are, as much as I've been back and forth through it, I voted yes to send Coburg forward because I kind of felt like we should go along with the local government there, even though I thought that was a flawed master plan also, and it was remanded. And I feel like if I vote yes on this, I'm setting it up for a remand. Unfortunately, I'm going to have to vote no on this.
Okay. Other comments? So this is an ordinance. Mr. Administrator?
Commissioner Sorensen.
No.
Commissioner Farr.
Yes.
Commissioner Lycan.
Aye.
Commissioner Bozevich.
No.
Commissioner Stewart.
Aye. So the motion passes 3-2. Okay. So the next one, I'll look for Commissioner Lycan.
Mr. Chair, I move approval of ordinance number PA 1341, the matter of amending the Lane County Rural Comprehensive Plan to modify official county plan and zone maps to reflect expansion of the Springfield urban growth boundary as amended by county ordinance number PA 1304 and adopting savings and severability clauses.
Second.
We have a second. Any further discussion on the motion? Mr. Mokajewski?
Commissioner Sorensen.
No.
Commissioner Farr.
Yes.
Commissioner Lycan.
Aye.
Commissioner Bozevich.
No.
Commissioner Stewart.
Aye. Again, it passes 3-2. And our third ordinance, Mr. Lycan?
Mr. Chair, I move approval of ordinance number 16-05 in the matter of amending Lane Code Chapter 10 to reflect adopted amendments to the Springfield Development Code to add sections 3.2-915, 3.2-930, establishing the agricultural urban holding area zoning district. This is Lane Code 10.600-15, adopting the severability clause, and that's it.
Do we have a second?
Second.
Okay. Further discussion? Seeing none?
Mr. Chair.
Excuse me?
Yeah.
Mr. Lycan?
So I just really want to speak to, being this is the final one to speak to this. This has been a long time coming. And I would suggest that I really like the college view. I thought that was for long-term future. I thought that was a very good way to go. But based on, I think, not just politically, but I think what is before Springfield, this is really to me, is a day that started my second term as mayor. And so I think this is going to be beneficial. As many of us know, we do need lands, what we call job-creating lands here locally. And I think we've been short for quite some time. And this is just this area alone and where it's located along the I-5 corridor, to me, really sends a very positive message that Lane County will continue to be open for business. And I believe that this overall, this is a good opportunity. I understand Commissioner Bozevich's concern. I will say that many members of the staff I've worked with over the years, and I have a lot of confidence in it. In particular, Linda Polly, who's to me has done an extraordinary job as a planner, and she's and not just this. We were working together in Glenwood as well in the past. Tom Boyd, I've obviously known for many years, even when he was at the dark side at ODOT. But just kidding. And anyway, and Mary Bridget, of course, is the attorney, and Annette. Didn't work with you over there, but worked with you here. So I'm confident that I think that this will pass muster at the state level, and based on the confidence I have in the Springfield staff. Thank you, Mr. Chair.
Thanks. And I guess I'd like to add that if it was reported correctly, 9 years of lots of work and a lot of meetings with the public, a lot of probably not so pleasant meetings with different public. So it hasn't been what I would consider a easy road to get to today. There's no guarantees. I mean, I think I've voiced my concern to the process. I'm a little bit concerned about how some of the new FEMA rules and some of those are going to impact some of these areas, probably a little bit more. I am, cautiously interested in, Coburg's item got remanded back because of the dedicated lands or development committed lands. And, I think there's findings in this that show a little bit different case. So, nothing's perfect, and we just do the best job we can with the information we have. And I just want to say thank you to staff for a lot of hard work and getting us to this point, and we'll just keep working until it can be implemented. So with that, any other comments, Commissioner Farr?
Thank you. I'd like to take a moment to commend the staff and the elected officials from Springfield for the deliberative and responsive process that they've gone through. It seems to have taken a long time. I've been a part of processes that have taken as long or longer and not produced an outcome. So you are producing an outcome. I'm personally satisfied with it. I think it's been a long time coming. I spent 10 years on the Eugene City Council. It didn't always come to fruition on our deliberations with the Eugene City Council. So I'm prepared to vote yes on this. Good work. Thank you for bringing this before us.
Thanks, Kier.
Any other comments? Okay, Mr. Mokahysky.
Commissioner Sorensen?
No.
Commissioner Farr?
Yes.
Commissioner Lycan?
Aye.
Commissioner Bozievich?
No.
Commissioner Stewart?
Aye. Passes 3-2. All right.
Thank you.
Thank you very much. Thank you, Springfield staff, for being here today.
Different reasons.
Okay, next item is 14. It's the Sheriff's Office. I'd like to welcome Linda Cook to join us. Not sure if Mr. Dingle might be coming. It is the second reading and public hearing for ordinance number 16-09 in the matter of amending Lane Code Chapter 20 to create a system for exercising emergency powers during a disaster. So we'll turn it over to Ms. Cook. Good afternoon.
Good afternoon. Thank you, Chair Stewart and Commissioners. As you know, I've brought this to you for a first reading, and it is a proposed ordinance to invoke emergency powers in the event of some type of widespread emergency or disaster that could strike Lane County. And just for context's sake and to refresh your memories, I would like to remind you of the types of disasters that could strike Lane County. I think all of us have our favorite disaster we tend to think about, but it could be some type of natural disaster where it's an earthquake, a severe weather event, a landslide, a hurricane, well, not a hurricane, I'll take that one out, drought, volcano, ice or windstorm. We could have a technological disaster that's associated with some type of hazardous material spill, perhaps a compromise at a hazmat facility. Biological and chemical disasters, which are any condition resulting from acts of terrorism involving bacterial pathogens, nerve gas, or lethal plant toxin. Or it could be a civil disaster, conditions of social unrest, including but not limited to things such as active shooting or active shooter incidents, bombings, etc. The purpose of me giving you those definitions is to remind you of the broad scope of emergencies and disasters that could strike, so that we think holistically about some of the threats and the risks that we face, not only as a county, but just as a nation and a human race. So anyway, with that said, we know that when these incidents start to unfold, that things can get very chaotic. People are not able to report to their normal place of work. People are displaced. A lot of chaos ensues. And so the reason we want to have this ordinance in place is so that we can restore order as quickly as possible, so that we can achieve continuity of government and continuity of operations in serving the public. And so this ordinance will allow for special powers to be invoked within the first 72 hours, where it's very evident to us that Lane County is at risk of widespread loss of life or widespread threat of injury or loss of property. And our goal is to make sure that we can very quickly invoke any type of emergency powers that may be necessary to protect the public. A good example would be what we saw last week in Gatlinburg, Texas, where they implemented a curfew from 6 p.m. to 6 a.m. for the sole purpose of protecting the public during those fires, because as we know, at nighttime, it can be very difficult to see and to get around, and they wanted to protect the public from any additional harm, and so they invoked a curfew. So that is an example of the type of ordinance that we're trying to pass here. So with that, I would like to ask if you have any questions or further clarifications as you have considered this over the last few weeks.
Okay. Questions for Commissioner Sorensen?
Under this ordinance, when we've identified this catastrophe, how do we declare that? How does the board declare that? Let's say we have a riot. Let's say we have a typhoon that reaches us. Let's say we have a tsunami, whatever it is. Mm-hmm. How do we go, it's cold outside, but is it a medical emergency outside?
Right.
How do we determine, which is it?
It begins with a situational assessment, and we identify how widespread is this incident, and we further take it and ask ourselves, is this something that we can handle within our resources? Are we fully capable of managing the incident without calling in, say, state or federal resources? Generally speaking, when we reach the level of an emergency declaration, we are finding that we do need some type of state, maybe a state special team or...
Who makes that determination?
The Board of Commissioners. So, okay, so you're asking more procedurally.
Yeah, okay, it's really cold outside today, but it's not an emergency, so the Board of Commissioners hasn't met. The Board of Commissioners knows it's cold outside, but it's not threatening the lives of too many people. My question is, what's the threshold to then have the Board of Commissioners go, it's sufficiently cold outside, or the wind is blowing sufficiently hard that we believe that enough people are being affected by this that we have to declare this emergency? Who does that? We do that? The board does that?
The board does. That is a very broad question, which is why I'm pausing, and I want to give you as succinct an answer as possible. It really relies heavily on situational assessment. If you want to put some type of metric to it, I would say if at least 25 households, for example, are without power, and they appear that they will be without power for 3 or more days, if there is a large swath of a geographic area that is where flooding is imminent, and we know that we're going to have to evacuate a large number of homes, or even, say, an apartment building. In Mapleton, we ended up in 2012 just evacuating one apartment building, but that incident rose to the level of an emergency declaration. But the criteria that the state looks at is this within the local community's capability to respond with its normal resources? So if we get to a point where this is stretching our resources and we're requesting resources from outside the area, and typically you can know that fairly quickly. If you think of the events of 9/11 or Hurricane Katrina, those kinds of events that are affecting the general public are, I don't know however, a better way to say this, but it's almost obvious that we've got a potential loss of life.
So let's just say, let's take the example of 25 people in Mapleton need to be evacuated. And the Board of Commissioners has heard from you, and we now realize this is beyond the scope of what we can handle. When we declare this emergency, are we affecting the rest of the people in the county, or are we just affecting the area within the county where there's an emergency?
Only the affected area. There are two types of declarations, and you declare an emergency or disaster so that you can invoke special powers and that you can become eligible for federal assistance. And there are two separate things that we look at. We look at individual assistance to individual households and businesses. Then there's the public infrastructure side, where our public infrastructure, our utilities, our bridges, our roads are being hammered. We have had more public infrastructure disaster declarations in Lane County than we have had individual assistance. In fact, in the 16 years I've been here, we've never had an individual assistance declaration. with that said, I have to roll back to situation assessment because it's the proverbial it depends. If we gather the right people in the room and we have good on-the-ground intelligence about who's being impacted in what way, then we know we need to convene a quorum of the commissioners as quickly as possible. If we can't convene a quorum because either one of the, 2 or more of the commissioners are unreachable or ill or out of the area, then we have a succession to that where it would be the sheriff, the chief deputy, the captain, or myself, or the emergency manager would then be in that line of succession to fill out that quorum. But we want to make sure that we have a sufficient number of elected officials available to declare that in agreement that we are facing widespread loss of life or injury.
How long does an emergency last?
Well, that's the nature of my, it's always the proverbial, it depends. A flood, we can be out of the woods in 72 hours. A lot of times that's waiting for the water to recede. However, in the 2012 flood, we were in recovery mode for 17 days straight. So,
And Health and Human Services had that emergency having to do with the communicable disease at the U of O for months.
right. This ordinance, though, we're looking at invoking emergency powers for the first 72 hours of an incident when things are most chaotic and response is crucial in terms of being able to react quickly in a short period of time. And so this ordinance would basically expire after 72 hours because the assumption is that after 3 days, we should now know the location of all of our elected officials. We should be able to convene under normal circumstances. It may be that a decision is made that we do need to still invoke some of those emergency powers, but the goal of this ordinance is to give the ability for an immediate response in the aftermath of something unfolding.
Okay, thank you.
Commissioner Bozievich.
Thank you. And I want to appreciate Linda and Mr. Dingle and the rest of the staff that put this together because it's a really well done piece of code. I think it very succinctly puts in place what we need to have in the moment as part of a disaster. It's very clear. If one of us, any individual board member or the county administrator thinks we've had a disaster or we have an emergency situation going on that's going to need these special powers, we can call an emergency meeting of the board. Any one of the 5 of us or the county administrator. And then if we can't get, it specifically says if we can't get all the board members together to declare that emergency, and there's definitions of what those disasters are in here and what an emergency is, and a reference to the ORS, including the year. Then it says, what's the succession? Who else can do that? If for some reason it's a countywide, windstorm, power lines are down, cell towers are out, no one can get a hold of anybody, and there's only 2 board members available. If the sheriff's available, the sheriff can make, and by the way, who's also elected by a countywide vote, can make that declaration. And then there's some other succession, and then it's clear that it's only a 72-hour that those powers are in place. And has some very clear things about, what authorities they may have relative to enforcement of orders and authorization to enter property. And of course, and it has some, some things in there that provide safeguards, like, a county employee can't, or authorized agent just can't enter a private property just because they want to under a disaster declaration. They have to believe that there is a true emergency and an immediate need for assistance to protect life or property.
And Commissioner Bozievich, if I may, that's exactly the same standard that police officers are allowed to use to make a warrantless entry into private property. It's constitutional.
Yeah. So it's not, this isn't really granting carte blanche to our staff. and it's providing some safeguards, but what's most important is it's laying it out in black and white. So in the moment of chaos and panic, after we have that surprise windstorm that the low developed over Florence and hit the valley without any radar detection, AKA, what was that, February 7th, 2002?
Yeah. Good memory.
Yeah. I was working in electric utility at that time, that's why. And absolute chaos happens, and it just happened to hit right after we'd let all the crews go home for the day, and they've worked a full shift, so bringing people back was also, never mind. And a lot of them had to get chainsaws out to get back to the facility just to get, it was incredible how widespread that devastation was in such a short period of time. That there may be that problem where we're unreachable, and we'll be in that kind of, oh my God, what do we do now mode? Oh, read the code. This is the order of things. First, try and get an emergency board meeting together and declare a disaster or an emergency. Okay, we're tried to contact but we couldn't get a quorum together. What do we do next? Oh, call the sheriff. Sheriff's not available. Who do we call next? Chief deputy. And it works its way down, and then gives us the ability to get to that point where we can have somebody that's authorized to make decisions on behalf of the county, to allocate resources, and to deal with the emergency in a nice, orderly fashion. And I really appreciate the way this was put together, yet it doesn't grant extra constitutional powers to anyone within the county.
Okay. Commissioner Farr?
Thank you. Just going to step by step through an emergency just so that I can kind of say it in plain terms. I'm 20.015 gives the definitions and information, 005 and 010015. Then we get to 020, the filing of a declaration, declaration of disaster by the board. This is in 020. And then I'll skip to 025, which is the terms of the declaration. A declaration of the local emergency shall be in effect as determined by the board for the period of time during which the conditions give rise. So the board declares the emergency. Now, the succession of authority, if the board is not able to meet in quorum, it goes to, as Commissioner Bozovich said, to the sheriff, the chief deputy, the police services captain, and then the emergency manager, in that order. So the emergency manager at that point would be acting as the board. So any place that says the board at that point, above that, at that point it becomes the emergency manager who is acting in lieu of the board's quorum being able to meet. I'm going all the way down the succession.
Right.
And then the powers under 035, the powers are granted to the administrator. So the administrator doesn't declare the emergency is declared by the board, which gives power to the administrator to do everything thereafter for the most part. And then it also says that the board shall be convened as soon as possible following the declaration of the emergency to make the next assessment on how long or whether to call off the emergency or to adjust the emergency. Does that seem reasonable?
Yeah, you're exactly right.
Okay.
Yeah.
So at no point does the administrator declare the emergency and then take the power.
That's right. No.
The emergency is declared by the board or by you, should the board and the chief deputy and the police services captain not be available.
That's right.
And then the administrator takes over. Okay, that seems reasonable, seems fully understandable to me, and it doesn't seem like any opportunity for the administrator to grab any unreasonable amount of power.
No, and that is why this ordinance is written the way it is, so that it doesn't allow any one individual to step in and act unilaterally or in any type of self-interest. That is totally about the evidence of a widespread emergency and that there is collective agreement that this emergency exists and therefore these special powers are needed.
And I would remind the board that one of the things we did do when Ms. Cook and I went back in order to make the ordinance symmetrical and parallel with the state powers, but we also incorporated those special provisions that you as a board agreed upon. Recall about how to communicate. We put those personal pieces in that you as a body decided, and among those were, for example, spending authority on behalf of the administrator and some of those other things. So this has not only the general Oregon statutory framework framework, but your own personal pieces that you thought was important and part of this process. And as I recall, it was unanimous. I think everyone on the board agreed to that, to those things.
And it delineates what is an acceptable means of communication, includes but not limited to. So it says it goes as far as Skype, but let's say 2 years from now there's a different technology. We don't have to delineate exactly what that technology is, but it is triggered into there. Okay, thank you very much.
I believe that's Commissioner Sorensen's contribution.
Commissioner Sorensen?
I just wanted to ask a question about the changing circumstances during an emergency. So the emergency starts out, Ms. Cook gets the phone call, lots of emails, lots of radio, maybe, and now we have, try to find the commissioners. Can't find them. We have a ordinance, emergency ordinance that we can look at. That's an improvement we're making today. And you end up declaring the emergency, you, Linda. And now the county administrator has powers that he otherwise wouldn't have had. But in the meantime, we found the commissioners. How does that change?
Let me just clarify, and I'm assuming you wanted an extreme example that you just came up with, but I do want to say that even through the line of succession, if no commissioners are available, we are still trying to get at least 3 officials together. So it would be the sheriff, the chief deputy, and the captain, or the sheriff, chief deputy, and myself. So we're still seeking 3 people to reach consensus that an emergency exists. Then, as the emergency gets invoked, to go forward with your question, the emergency gets invoked. We're in the first 72 hours between the sheriff and the county administrator. They've deemed that the county administrator does need to be exercising some of these powers. And then if, all of a sudden on day 2 or day 3, the commissioners have been located and they're in the ability to communicate, then we call an emergency board meeting and we update you quickly, and we do a report. And then I think it would be reasonable. We haven't been through this, but my stream of consciousness would say, do you concur with the way that we're proceeding? I would want to get that approval retroactively. And if for some reason you felt that we had overreached or we need to reverse course, then we would certainly want to hear that.
Mr. Dingle, do you have the same view that once the sheriff's office has invoked the emergency because they can't find the commissioners are dead or they're out of communication, and so someone has to do something? That's what this ordinance is all about. Someone does something, they declare this emergency, county administrator and or designee run off and hopefully solve the emergency. But now during the process, we find the commissioners. We find 3 commissioners. What do you, is there, first of all, just legally, is there anything in the ordinance to deal with that situation, or is it only the hypothetical in which we cannot find the commissioners is in the proposed ordinance?
Right. So the way I read this as a whole, and as I was looking for the portion that Mr. Mokrahajski pointed out under powers, my interpretation is that the ultimate authority when it comes to, and the preferred authority, I think Ms. Cook agrees with this, when it comes to handling this, is the board. The triumvirate of other officials that fill in temporarily for that quorum, it is indeed, they are temporary. If on, I think the question that you're asking, Commissioner, is if under 20030 the succession moves, that group does not have power for like 72 hours that trumps the board. If the board if the board is unavailable for the first 24 hours, those folks will make the decisions. As soon as a quorum of the board gets together, the board is back in charge. Mm-hmm. I think that's the question you're asking. Yeah, yes, the board is always ultimately in charge. That succession, as Ms. Cook said, is simply a stopgap. So there is no gap in that period of time where we might not be able to communicate with 3 members of the board, and everyone sits around and says, "Well, I guess we can't do anything." Mm-hmm. Right. That's the situation we're trying to avoid. But no, to answer your point, Commissioner Sorensen, the board directly would come back after 24 hours, convene an emergency meeting, and make whatever decisions they make.
Thank you.
Commissioner Lycan.
Thank you, Mr. Chair. So just to refresh the memory now, bring for the board to be at least 3 board members for a quorum, and to move forward on this, don't have to be live in person. This could also be communicated by cell phone or phone. So if Commissioner Sorensen's in Maui and Commissioner Bozovich is in West Lane digging ditches and I'm out on the golf course, we can all communicate by phone to make sure that on this issue. Is that correct?
That's right. I do want to add, we would want a way to authenticate you, which means we would need to know ahead of time what your phone number is. I'm assuming text messaging at that point, or perhaps a landline telephone call, or, as the ordinance says, Skype, whatever it takes.
And I think we've actually taken steps, and I believe it was, again, Commissioner Sorensen who suggested this, but I think right after this, Ms. Jones has all of your preferred methods or potential methods of contacting you so that we could take care of that. And we added the language that said, or any other method permitted by the Oregon Public Meetings Act to cover theoretical future changes in that regard.
Well, and I think that's important. I just want to say, this is, to me, I believe what's before us makes a lot of sense. I mean, there's obviously a lot of discussion about, what may or may not happen. It may not happen in our lifetime, but the Cascadia, obviously, and Linda, you've been highly involved in working with your colleagues around the state and around the region about, if that were to happen, how do we start in that process? I think it makes sense. And I've had conversations with my fellow commissioners, my colleagues in Central Oregon, Deschutes County, where Redmond's ground zero, and which literally puts them as some of the most powerful commissioners, not only in the state of Oregon, but really in the Northwest. Whether they like it or not, that's the reality. But I think it even goes beyond that. I think just we saw firsthand what happened in Japan. And next thing you know, we're seeing stuff that came from Japan floating up on our beach in West Lane. And so I think from this standpoint and how this is put forth, and by the way, I like the idea that if it's not the board, the succession is the actual emergency operation personnel, the sheriff, the chief deputy, yourself, the folks who actually are on the ground and understand what it takes if an emergency is declared, what it takes to start moving the process forward. To me, I like that succession. I think that makes a tremendous amount of sense until 3 members of the board then are available to, as Mr. Dingell suggested, that even after a declaration, the 3 members of the board then or the Board of Commissioners as a whole, are then back, for lack of a better word, in charge. And so I think that what you really have worked on and what we worked on really makes sense, and I appreciate the work. Thank you.
Commissioner Farr.
Thanks. Just a clarification. A quorum of the board is required, so at no one point can the chair of the board make the decisions for the entire board. It goes to the sheriff before that happens.
Mm-hmm. That's right.
Yes. And just the definition of sheriff, if the sheriff is gone and we have an acting sheriff, the acting sheriff is the sheriff.
Yes.
In that definition. Okay. I'm covered. Thank you.
Mr. Bozovich.
Yeah, I just want to point out one other little safeguard that was built into this ordinance, and I don't know if they did it knowingly or unknowingly, but in the succession to the board members, the county administrator is the one that gets granted these powers and his designees. We are the county administrator's boss, so he doesn't work for us. But what's interesting is everyone else that's in the succession is either independent elected official or an employee that is under the chain of command of that independent elected official. So technically, the folks that are in the succession don't work for the county administrator. So the decision to grant those powers, there's nobody that actually works for the administrator. So it's not like we have the public works director in that line of succession who actually is an employee and under the supervision of the county administrator. So I think, it was a really smart thing to do to have the sheriff's office involved, and that way it's very clean, that it's not some power grab by the county administrator to have this, to convince some employees to declare an emergency, so he has these extraordinary powers he normally wouldn't have, or he or she, because this could be off into the future. But, there's the folks that are making those decisions are either that administrator's boss or folks that don't report to the administrator. So I think that's another safeguard that's built into the writing of this. And I don't know if that was done with intent or if that was just happened to be, but I think it worked out really well.
Commissioner Bozich, I don't think it's an accident. I think one of the reasons that the ultimate people with responsibility, you'll notice, are all people who are ultimately responsible to the electorate. They're elected officials. Mm-hmm. The sheriff's elected, you're all elected. So at the end of the day, there is accountability to the citizenry in the form of an elected official as opposed to an unelected official.
I guess I would just point out that it hasn't happened in recent years, I think probably because of resource. But there were years early on in my presence on this board when there were 3 commissioners that went back to a NACO legislative conference in Washington in February. And, it could be a situation that, Lord willing, plane doesn't crash, or after you get over there and there's communication difficulties because we have a storm that's hit the Pacific Northwest or something. So, those are circumstances that nobody can predict that are going to happen, that I think it's prudent business to have a process in place for us to be able to handle those circumstances if they ever arise. Commissioner Sorensen.
I was going to mention we've had, and this is more in the deeper past, we've had situations where there was a need for an emergency session of the board, and the person in the role of Ms. Jones couldn't find the commissioners, and so we had a delay in having the emergency action take place because they couldn't locate the board. I think we've also had situations where, I'll say, important people were on county business, the county administrator, several department directors, and they were out of state, far away, on September 10, 2001, and the county administrator had to drive from close to Atlanta, Georgia, to Eugene, Oregon, because he could not fly. And he was in touch by telephone during some of that period of time, most of that period of time. But if that had been 3 commissioners, that would have been a different story. So what Commissioner Stewart's pointing out is that it is very real. Mm-hmm. The part about Maui, I think, was made up, but the rest of that was all true.
It was made up.
All right. So are there any other questions of staff before we open the public hearing? Okay. I'm going to make an assumption here that we have one person that signed up. We have no one signed up. Well, I'm going to open the public hearing. Look, Mr. McFadden, you want to give some public testimony? All right.
So I was able to make it here, thankfully. Clearly, I care a lot about this. And I think that maybe I care a lot about it because I have a lived experience that's unusual to what most people have ever lived. And that is that, I survived the broken foster care system. And I have seen directly in my life and people I care about's life how when systems of government are dysfunctional and neglectful, people get hurt. And so I know that's completely unrelated to the disasters we're discussing. But so I have that lived experience of knowing that and experiencing what happens when the government fails you and fails to keep you safe. And so, I hope that any of the concerns I have about this emergency powers ordinance are as rare as any of the emergencies that might actually happen. But that being said, I do think that I'm going to go grab my papers. There's a few things in here that are really concerning. And I do agree that a government such as yours needs to have procedures in place. And it's not like I think that there's a Machiavellian plot or a conspiracy theory of the board or the county administrator or any of the county staff to like have some big, dictatorship of Lane County. No, I don't think that at all. But my own experience is that in times of crisis, people either make really good decisions or they make really poor decisions. And oftentimes those are the times when there's minimal oversight of the kind of decisions that other people are making, and the kind of, accountability often comes after the fact. And so when I look at this language, I see all sorts of opportunities for people who don't have the respect for other people or the rule of law to abuse this power should it end up in their hands. And I'm not saying like the administrator, but, any number of people. There's language in here that says like certain classes of people could be singled out in a curfew. I'm sure none of this would ever actually happen, but, based on reading it, the board could order, restricting the production of food. And I also see, depending on the political climate of what the emergency is, what may or may not actually be an emergency could depend on the political leanings of the board or whomever's making these decisions. Civil disturbances, social unrest, a lot of that's pretty nebulous language. So, depending on how disastrous that is, or how disastrous some people might feel like it is, those powers could be delegated to quash a demonstration that could be labeled as a civil disturbance. And so, in light of things that have been happening in North Dakota and other things, I just think that in times of actual crisis, the temptation for people to do bad things is there. And if there's not a mechanism to keep people accountable, then there are people out there who are going to overstep that and are going to abuse other people. And unfortunately, oftentimes, like I said this morning, it's way after the fact before anything ever is done to right those wrongs that happen. And so, I would really like to express these concerns, but I reiterate that I'm not an unreasonable person who's just spouting conspiracy theories. I really do have true concerns.
Thank you. Seeing that there's no one else present, that will conclude our public comment period. Any responses to the comments?
Yes, I would like to point out that when you look at the definitions under 20.010, one of the examples that was offered by Mr. McFadden was looking at the definition of civil disaster, which is, I think is what he was referring to. That is qualified by the word disaster up above it, which requires, which as you can see is a pretty extensive situation. In fact, it must exceed the ability of the affected community or society to cope by relying solely on its own resources. So it's not, so it doesn't include, an assembly of 100 people. I just want to make that clear that the word disaster that appears first qualifies and becomes a part of civil disaster, natural disaster, technological disaster, or biological or chemical disaster. It's always going to have to meet that baseline threshold of exceeding the resources of the county to cope with it, to even meet the threshold.
Okay. Commissioner Farr.
Thank you. Mr. McFadden, thanks for your testimony this morning and this afternoon. I want to let you know that after you spoke this morning, it caused me to step back and take a look and make certain in my mind that there were no opportunities for any one person to seize power without it being overseen by another person or the board itself. And I reviewed that, I tested it in my mind, and I'm satisfied personally that is a situation that is at the best we can possibly do, avoid it. We wish and hope there would never be an emergency. We wish and hope that one person would not have to make a decision that affects the entire county or beyond. Nationally, that one person doesn't have to make a decision to affect us. But in reality, that potential does exist, and having a plan in place, the best plan that we can come up with to make certain that no one person grabs the power and seizes it for all he or she is worth, that is avoidable by the plan that we're putting forward. thanks for your testimony this morning. You did cause me to reflect. You caused me to think about it. And you made me put together the words where I stepped through it in what I viewed as plain language. What is the process that gets us to the administrator having the powers described from 2.20.020 on down? So thanks for your testimony. I heard you. I listened to you. I reflected. I tested. And I came up with the satisfaction that we do have a good plan in place here, the best one that we can do in the situation that may arise, that hopefully never will arise, but may arise. So thank you.
Thank you very much. I too want to say that I wasn't really planning on asking those questions because most of those questions were dealt with in our lead up to today, but or as was mentioned, the testimony about, well, how far does this emergency ordinance go and who can invoke it and who can, assert singular sole authority over it. To me, the answers that have been given by the emergency management people and the lawyers have been, I've answered those questions pretty thoroughly, that no one person really can do much here on their own. There has to be someone in the chain of command from the commissioners through the sheriff's office to make the actual declaration, and then it's the county administrator that takes over from that. So that's a real important fail-safe. In a true coup, the people organizing the coup end up running things after the coup, and that is not what's here at all. So I think that, but on the other hand, when people come from the public and they come in and ask these questions, we have to be willing to listen, and I think we did listen. So thank you for coming in.
And I'd like to add, I really appreciate, the additional testimony and the address by legal counsel. I mean, if you just happen to skip over the disaster definition and you go to civil disaster and you look at an unlawful assembly and that's by itself, there's no definition, but you have to include the disaster component, whether it's, like I said, threatening widespread loss of life, injury to a person, property, human suffering, and financial loss, and beyond the capability of our own resources to respond. I mean, if you're looking at things individually, you can probably come up with some questionable concerns, but if you view it in the way it's intended to be viewed and used, I believe personally that this is appropriate. It's state law, and now it's going to be our code.
And as a final point I'd make to the entire board, if you look at 20.060 sub 2, it makes it clear that there's that nothing in this ordinance is intended to grant any power that or authority that doesn't already exist or authorized by state or federal law. It's explicit in that it's not granting any extra statutory or extra constitutional powers to anyone.
Other comments, Commissioner Bozevich?
So one last comment is that, there's always, as you're looking at emergency powers, that danger of abuse of those powers. But one of the things about not having this clearly spelled out in our code is the harm that would be done in not having an organized response to an emergency and the delay that might happen without a clearly spelled out procedure for how we declare a disaster, what powers are granted, the limitations on those powers, all those things, being contained in black and white right there in lane code. To me, we have to balance those two things because there's harm in not having clear policy. We can all imagine 1,000 different situations where if we're not quick in responding and delegating authorities and allocating resources and being able to reach out to other agencies outside of the county for assistance, people's lives, may be in danger. And this allows us to get to those places very quickly. So yes, there's always the risk when you adopt emergency powers that there may be the one person that doesn't exercise them well. But there's also the downside risk of not having a clearly spelt out emergency declaration process. And I think this balances those very well.
Other comments, questions, concerns? If not, I would entertain Commissioner Bozievich.
So I'd like to move approval of Ordinance 1609 in the matter of amending Lane Code Chapter 20 to create a system for exercising emergency powers during a disaster.
Second.
Say that 3 times real fast.
We have a second. Further discussion? Seeing none, Mr. Mokowski, it's an ordinance.
Commissioner Sorensen?
Aye.
Commissioner Farr?
Yes.
Commissioner Lykin?
Aye.
Commissioner Bozievich?
Aye.
Commissioner Stewart?
Aye. Passes 5-0. Thank you very much.
Thank you.
Okay. So on to review of assignments.
So I missed something, Mr. Chair. I don't have any, although I presume after our...
That can't be right.
Well, I'm waiting for tomorrow's work session on the strategic plan and my goals, and I assume we'll have plenty of assignments to review at that point.
Make it up tomorrow, right?
Yeah.
Take a break today. Okay, we do have an executive session, and before we do that, I want to, during the lunch hour break, I was able to check my mailbox, and I received a card here from Captain Chris Enquist from the class training coordinator for Academy Training Division for the state of Oregon. And I just want to read it. It says, good morning. I wanted to take a moment to thank you and your county for your staff's contributions to the training program for the parole officers here at DPS-ST. Staff from Lane County Parole and Probation play an integral role in our training here and help ensure our practices are effective and relevant. DPS-ST has the benefit of lots of support from Lane County, and I'm personally very thankful. Thank you. Please pass my thanks to the other commissioners, to Steve and to Donovan. Chris. So I just wanted to share that. I'll try to get Deanie to scan it and send it off to Donovan or give him the card, but wanted to pass those kudos forward. So thank you. Is there any other business before we go into executive session? The only thing a couple things that I would mention is we do have work session tomorrow upstairs in the conference room. And then I just want to give you a heads up for next week. Next Tuesday and Wednesday are potentially, it's not potentially, Tuesday is a very full day. Wednesday morning is full. We have added a discussion in regards to the city-county partnership in the morning following the Fair Board. And then we have reserved, doesn't mean until we get certification or notice from the Secretary of State, we have reserved the afternoon of the 14th at 2:30 to potentially interview candidates for the soon-to-be vacant Senate seat of Mr. Edwards for replacement recommendations. So if that doesn't happen, we will monitor notice from the Secretary of State as to when we receive that and can process a meeting. Potentially may have to call an additional meeting over the holidays to accommodate that. So with that, the Board of County Commissioners will meet in executive session to consult with counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to ORS 192.660 subsection 2H, which allows the Board of Commissioners to meet in executive sessions for the purposes listed above. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decisions will be made in executive session, and we do reserve the right to come back into public session should the need arise. So with that, we will move to the Commissioners' Conference Room and hold the executive session.